Well, outside the tribunal here, second day of what was being said. With me is Andrew, who's been on my programme only the other day. Andrew, Green Party, of course, and also a practicing advocate. Well, let's deal with today's things, because that's it. That's all we're going to get now.
Yeah.
What did you take? Because it all started off quite dramatically with this new letter from the ex-health minister, which I've done an interview. Literally, I came from my studio down here to talk about. Did that shed anything into the proceedings for you? And what did he say?
Well, we haven't seen the letter, and so extracts were read out in court, and it seemed to be, and I haven't seen the letter, so I'm just trying to recall what was said. He was challenging maybe what had been said at the court hearing, or maybe indicated or alleged that he hadn't made certain searches of his email account, and there seemed to be an indication today, initially at the hearing, that email account couldn't have been searched by the department, but then that position was rolled back later on in the hearing, where it seemed to be that might not be the case, and it might be the case that the department could have searched.
Well, he was saying that at least one of these letters was there, but then it came down to how come it wasn't found, and this whole question about these bundles, and was it in the bundle, was it not? And the AG's department constantly came up in what they got, what did they hand over? What do you make of what that was going?
Well, I mean, there was a lot of issues raised today for the representation for the department, and yesterday at the hearing, that this hearing, why is it going on? And I think Dr. Ranson's legal team made very clear that the department had known about this hearing for a long time, and this was their opportunity to really clarify their position. There was a judgment, a 202-page judgment on the 9th of May, nearly 4 months ago, stating exactly what the tribunal's initial findings were on the failure to disclose, and holding a hearing to really give the department, this is the department's opportunity to go, actually, this is our explanation for what's taken place. And it seemed to be, and I haven't read the tribunal hasn't issued a judgment on this, but hearing both parties, it seemed to be from the department's point of view that, well, we've changed advocates late, and now we don't really know what this tribunal is going to do with this hearing, why we're here. We haven't had legal arguments from Dr. Ranson, and Dr. Ranson's legal representative, Mr. Siegel QC, he stood up and said, well, they've known this for 4 months. They've known exactly why they should be here giving evidence to explain their position of what's gone on, and then an opportunity for the tribunals to make findings.
It's a tactic, and I dare say, I'm not saying it's any way that I would say it's attached to this one, but it's a well-known tactic to put in new representatives at the last minute, which causes a delay and more time wasting almost, isn't it?
Again, these points were said in open court today, and I'm not creating them. I'm just repeating them for the benefit of the public. And really, I think the legal team for Dr. Ranson, Mr. Siegel QC, he accepted that there may be reasonable grounds to change lawyers because of the specific allegations about the disclosure process, and how the Attorney General's chambers were an integral part of the disclosure process as the legal advisors for the department. So he accepted. What he did indicate, or maybe imply, is that the department could have changed their lawyers a lot earlier, and this is what he said, not my interpretation. And it's open to a fair-minded person to draw their conclusion about whether it was right to change their lawyers this far on, or whether since the 9th of May and the liability judgment, they've had clear reason maybe to change their lawyers, and Mr. Siegel QC just said there may be grounds for them to change their lawyers. However, to turn up today and say the reason why there should be a delay was solely because of the change of lawyers, he suggested didn't really carry water. I think he said it was breathtaking at one point why the department were turning up and making points that we're not really clear on what the tribunal's going to do with this disclosure hearing. Maybe it doesn't need to make the findings of fact, which the High Court now, I understand, a judgment has been handed down by Deemster Corlett since Friday, the hearing on Friday. That's now published on judgments.im, so the public can go out and read that. That's only, I think, published today, but it was referred to at the hearing. Deemster Corlett's made very clear what the tribunal is supposed to do. It's making findings of fact. I think there was a quote, a fact-finding task was how the Employment Tribunal referred to it today, the Employment and Equality Tribunal. That's its task, a fact-finding task to discover what's gone on in the failure of the department, as declared in the 9th of May liability judgment, to properly disclose documents.
A fact-finding task that behind us the High Court had to be challenged on, basically, to make a ruling last week about.
That's correct, yeah. So that was obviously added a whole new set of proceedings.
You just get the impression that there's a lot of people who don't want any of this to go any further, or certainly put more time delay. But just making from my notes, the Maxim Malone thing, that they cannot be made to attend, they don't have to make statements. This leaves a hole in proceedings at the end of the day, doesn't it? Because we really need to know what they did know and what they didn't know, and have them under oath again back here in front of the tribunal. But that won't happen.
It doesn't appear to be. I mean, the tribunal hasn't made any orders.
They've got no jurisdiction, have they? They're, well, certainly for Malone, who's in the who's in the UK, so they can't do much.
Well, yeah, the tribunal hasn't made any specific conclusion about its jurisdiction or what it will or won't do. We haven't heard an order issued today to the effect of that. I mean, we understand now, day 2, there was going to be 3 days this week. Now there's only going to be 2 days. It's finished now, and it appears to be the case that the tribunal is going to make an order, and that's going to give further direction. We understand, people who attended the hearing today, that the department are going to somehow, I think it's suggested, not explicitly stated, going to work with the Attorney General's chambers, and there is going to be leave for the department to file maybe more evidence or more legal submissions, and liberty for Dr Ranson to respond to that. So there might be another hearing in due course. We know there's going to be another hearing around Expol, which is dealing, I heard in open court, on the alleged concoction of documents.
The metadata.
Yeah.
Now that could have been October, but now there's potential that it may be earlier, so we wait and see on that one. That could be interesting to see. Both parties were given a sort of outline of potential damages today. I mean, that was from the tribunal, so that bit could be looked at now then, the idea of ballpark figures, I'm guessing, and discussions about how much money that the doctor should be getting out of this.
Well, it was stated last week in the High Court hearing that apparently, it was stated in open court, I think, that a schedule of damages has now been maybe served on the other side. I think it was only a passing reference, so there might, I haven't seen these documents, I'm just listening to what was said in court, there might be some then quantification as to the damages. I think Mr Siegel QC referred to an application for damages, but I think that was on the basis that he was going to make the application sometime in the future. We know the tribunal's listings has got the liability hearing already set out for time in January, so that's going to be dealt with then.
Yeah. No one there actually representing the Attorney General's chambers, of course, is there? But there's so much talk about them constantly and their performance. And from what I understand behind the scenes, and I don't ask you to comment upon it, there is certainly some questions that must be asked about the Attorney General's chambers, and I think that would need to be sorted out at some point, don't you think? Are you allowed to comment on that? Was that too...
Well, I can just repeat what I've heard in open court today for the benefit of the wider public, because there's a huge public interest in this case. It goes to the heart of governance in the Isle of Man. So I think what Mr Siegel had said yesterday in his submissions and then today was that there was a possibility, and he was inviting the tribunal to draw an inference that there had either been selection of documents from Ms Magson before they reached the Attorney General's chambers, or in the Attorney General's chambers themselves. He was inviting to make the tribunal to make an inference. That was challenged today on the basis that I think Mr Wilde, for the respondent, said there was clarification that all documents had been sent as maybe implied as reviewed by Miss Magson. I think that was the case, suggesting, I think, implication that the Attorney General's chambers had got what had been vetted by the department by Miss Magson. Yeah. So it wasn't the department involved with selectivity. But Mr Siegel got up, then said, OK, if that's the case, what the Attorney General's chambers should be turning around then, and when they received later documents from Dr Ranson, which were the missing documents in that disclosure, is suggested that they should have highlighted, well, there's a difference here between what we received from the department and what we received.
And they were both the same searches, weren't they? From all accounts, the same triggered words were used, and yet two different conclusions were reached, which, again, we touched on this yesterday, that Magson seemed to have had a list that was finally up to her to get her approval what was actually sent on, which of course opens so many more questions again.
And that's it. And Mr. Siegel said that the Attorney General's chambers, there was a question about what they should have done then when they recognised there were two sets of different documents that didn't add up. But these are issues that are going to be dealt with by the Tribunal in future. I'm just repeating what was said in the Tribunal today.
Well, thanks very much. I mean, it's something that's causing interest all over the place. But as I just want to finish this, the conduct of the Attorney General's chambers was called into question. I mean, I wrote that down on the thing, and clearly that's something that should never be the case. I mean, we all trust that the Attorney General's office is squeaky clean, don't we?
Yeah, and Mr. Siegel seemed quite frustrated that this hearing had been constituted, had been listed to give an opportunity for the department to clarify and clear up all these issues.
And that's what it's about, wasn't it? To actually answer these questions.
And I think he
he
used the term breathtaking, that the department were now turning up and had not taken the opportunity, his words, to clarify these issues.
Silence was definitely going to be used the other day as well, didn't they, I think?
Yeah, and he quoted that from, I think, the judgment and liability judgment in the 9th of May, saying these were the words of the Tribunal, that the silence was deafening. When he was challenged on those specific words, he was saying, well, these are the Tribunal's words, not mine. I'm just borrowing them to indicate that there was still outstanding disclosure from certain members of the government who hadn't taken the opportunity to file affidavits.
Well, it could be October, it could be sooner, but obviously we've got the result. He'll give his understanding of what happened over these last few days. That'll be coming out. How long does that take? Do you know? I mean,
Well, I don't know if there'll be a judgment from the Tribunal now. He's going to. The chair suggested that he would issue an order, directions order.
What's that mean?
So that will basically set out, because my understanding from the hearing is that the department is going to have the opportunity to file new evidence and maybe legal arguments. So that will say what date that evidence should be filed by, should be served on the other parties. The Dr. Ranson's team then, I believe, would have an opportunity to respond to that if they should so wish. So a directions order is just a timetable for the Tribunal. It's not a judgment that states legal rights, and so to speak.
So to be continued anyway, be it October, be it definitely January, because they'll be coming back for more, but we'll keep on abreast of this. And thank you, Andrew, for your time and your knowledge on this story that is just doing an incredible amount of damage to the legal profession in general. I think in the sense of what's been going on here around not the Isle of Man, but also further afield, hasn't it? Ramifications.
Yeah, but as I'm quoting Mr. Robert Shaw previously, who highlighted the great value in our governance system in the Isle of Man, that we have the Tribunal and the courts to ventilate these issues and draw conclusions on them.